My name is Rebaune Gaurailui. I'm an admitted advocate, and I work for ECSA as a divisional executive responsible for, amongst others, the legal services unit. And the legal services unit is responsible for monitoring and regulating the conduct of people that are registered with ECSA as engineers.
Perfect. Very good.
Part of statutory functions or regulatory statutory council's function is not only to register people but to also regulate their conduct because they go out there in the name of professional engineers, technologists and so on and so forth, get jobs, take decisions, and it's important that from time to time we monitor and where necessary take the necessary action in ensuring that whatever they do, that they do at the highest levels of professional etiquette, high levels of ethics, and of course good workmanship. Being a professional engineer means you are competent. And if any report is received by us that suggests substandard workmanship or competence or unethical conduct, the legislation, the Engineering Professions Act, empowers us to not only investigate that, but where necessary, take the necessary corrective action. Yes. By its very nature, investigating people and taking disciplinary action against them, it's inherently legal. So ECSA has got a well-established and competent unit called the Legal Services Unit. They are responsible for overseeing this function.
How many people are in that unit?
It's staffed by about 5 people, 2 of them professional legal people, and with administrative staff. The enabling instrument obviously is the Engineering Professions Act, which says that whenever registered people are found to have conducted themselves in a manner that's wanting in those areas I've mentioned earlier on, then action should be taken. That's the enabling legislative instrument. But the day-to-day instrument that ECSA uses, it's a code of conduct for registered persons. Every registered person, once they are confirmed registered, know that there's a code of conduct that they must subscribe to, which is in the ECSA's website. That's a document that will tell you the do's and don'ts of a registered person in terms of their conduct. That's the instrument. It is a council-approved document, which is gazetted, and from time to time we do review it, yes, because situations change, and as and when there's a need to tighten it, we do that. In fact, the development of the code of conduct, it's an instrument, it's a process that is that involves the registered persons themselves. There's a committee in ECSA called the Investigations Committee. Right. That committee is actually the custodian of the code of conduct. They are the ones that panel beat it. They are the ones who have put it together, of course with legal support and legal help. So ultimately it's a product that was developed by the very engineers to apply to the engineers. Yes.
They're being held to their own standard.
Indeed.
Right.
Yeah, it's not something that was developed by lawyers and imposed on engineers. The engineers themselves constitute the investigation committee. It's them that from time to time decide if there's a need to review it, right. And it is indeed their document developed by them. Right. The code of conduct is promoted first and foremost once you are confirmed registered. It is brought to your attention to say, as a registered person, you have to subscribe to a code of conduct, which is posted on the ECSA website. So the promotion thereof is through using the very registered persons in investigating conduct, using the code of conduct as a Bible. As I said, they are members of the investigating committee. Even when we constitute disciplinary hearings, the panels themselves that have to oversee the process are registered persons themselves, of course, with the assistance of a lawyer here and there, and they use as a source of reference the code of conduct itself. Yeah. There are, before we talk of, or we've talked about promotion, The other thing I forgot under promotion, by the way, from time to time we publish advisory notes. An advisory note would be saying that recently there's been a building collapse in such and such a place, and what was found in that building collapse was that there was a fault in this and that. Therefore, please, out there, be careful when you sign off, before you sign off on a building, to make sure that this and this and this is taken care of. In that way, it will avoid the recurrence of a similar incident. Yeah. So from time to time, ECSA would pick up a trend in terms of flaws in engineering work out there, and they will publish public notices and advisory notes, and therefore, in a way, advise engineers out there to say, guys, this is how we should do things as opposed to doing these things. Coming to the enforcement itself now. Once a complaint is received, in other words, there are two ways in which ECSA gets involved. Either it receives a complaint or on its own discovers that there has been conduct somewhere or a building collapse, or so on its own, ECSA can decide to investigate. Once it's found that there's substandard conduct on the part of an engineer which necessitates corrective action, then ECSA will enforce its code of conduct by calling, by firstly investigating, and thereafter calling a person found to have been responsible to answer to the charges against them. So if they are found to have transgressed and the panel found that they are indeed guilty, the necessary and appropriate corrective action will be taken, which could range from rehabilitating them to warning them to even deregistering them from the register of registered people. Recently, ECSA held road shows throughout the country about what it does. And one of the questions that kept on being asked is what is the benefit of being a registered person? In fact, the benefit of being a registered person is to make sure that if any one of your peers out there conducts themselves in a manner that's unacceptable, then your reputation and the good standing and your competence as a registered person will be protected by taking action against that, on the one hand. On the other hand, the public out there need to know that it's important for them to use the registered persons to sign off on their houses and any other engineering work. Government, municipalities need to have comfort that when we use registered persons, we know we've got recourse, because should they sign off on work that's found to be wanting later on, then we know that ECSA will protect us. So protection of the public is important. That's why it's important for ECSA, as part of its regulatory function, to take that action. No. Simple answer to that is no. The Engineering Professions Act has got remit within the borders of South Africa. Therefore, if you've got an engineer who's registered, who gets commissioned to go and do work in America or somewhere, and they are found to have transgressed there, ECSA cannot come back here and say, for the work that you've done outside South Africa, you are responsible. So its remit and its jurisdiction, it's within the borders of South Africa and not outside, even if you are registered and you do work outside. The effect of the outcome is that it varies. The overall objective, maybe I should start there, is to correct substandard behavior or unacceptable conduct. But the effect is to make sure that engineers who are registered out there know that they need to subscribe to a particular level of standard, and failing which there will be consequences. So the effect actually is to ensure that our engineers out there conduct themselves in a particular standard and not below that particular standard. And once we take corrective action, we enforce that corrective action, either by warning you, like I said, it's wide-ranging. An engineer could even be deregistered as a professional engineer. There are two areas that are of concern to us. Obviously, issues around building collapses seem to attract a lot of media attention. And in doing that, it necessitates on our part to notice the trend as to what are the typical areas that are found to have gone wrong, and then proactively issue practice notes to actually assist our engineers out there who are registered to say, these are the things that you need to do, these are things that you're not supposed to do. So the developing trend, as I said, is building collapses. But given the environment under which engineers work, you would remember the well-publicized collusion during the 2010 World Cup, construction collusion. And I think it's important as well from our side to issue practice notes around issues of probity, of high levels of integrity, that our registered people must be careful in how they conduct themselves ethically. And I'm talking here corruption. Yeah, those are the two developing areas around the regulation of engineers. One, workmanship, building collapses, and the other, ethics. Ethical conduct, decision making is very important. If you look at the code of conduct, you'll see that it's not only about workmanship, about what you do on a day-to-day basis with your hands. It's about decision making, it's about high levels of ethical conduct. And if it's found to be wanting, that could be a basis for corrective action as well. There cannot be, because in the assessment and the evaluation of competency for registration, one of the things that get examined is issues that we are raising now. How competent are you to do the work? Are you going to do the work within your category of registration? In other words, if you are a technologist, you cannot go out there and claim to be an engineer. If you are a technician, you cannot go out there to claim to be. So when they leave the registration process, they know that which they've been registered for and that which they've been competent for, firstly. Secondly, the code of conduct is actually part of the evaluation as to how they ethically will conduct themselves out there. And it is on our website, and every engineer knows that they are subject to ECSA's code of conduct. They cannot claim ignorance. Yes. If a registered person is in cahoots with or is involved in a project that they knew or ought to have known that it's laced with corrupt activities or whatever, and indeed they could be subject to disciplinary action. In terms of ECSA's legislative framework as well as the code of conduct, any action that is taken against any registered person against which they are unhappy about, they can take recourse, they can appeal against that. For an engineer to take legal action, it's a prerogative by any person to take at any point. For instance, an engineer could decide to interdict ECSA, for instance, from implementing or publishing the sanction on the website. They could interdict ECSA from taking action against them at hearing stage. ECSA cannot dictate or regulate at what stage do you go to court. It's the right of any citizen to go to court at any point once they feel that their rights have been impinged upon. However, for purposes of reviewing the sanction imposed, the appropriate time to actually take recourse legally would be after the appeal has failed. I think it needs to be mentioned that ECSA's jurisdiction is over registered persons and registered persons only. There are a lot of people that practice in the engineering field who are not registered with ECSA because there's nowhere where the Act says it is compulsory that every engineer should be registered, as is the case with the medical profession. Every doctor cannot touch a patient unless they're registered with the Health Professions Council. As a result, you have an influx of people that come from other countries that want to practice engineering here. The Department of Home Affairs have tried to regulate that, to say that no engineer can practice in South Africa without a critical skills visa. But the fact of the matter is that they do. I mean, there are a lot of foreign engineers that practice engineering in South Africa that are not registered. But it is a concern for ECSA that there are people, firstly, once you come here as an engineer and you say you are registered, we need to verify your qualifications, whether indeed you've got an engineering qualification, and if so, if it's in line with South African standards of post-matric qualification. And secondly, ECSA itself needs to determine, in terms of, because ECSA is a signatory to international accords, whether that foreign qualification you bring here is in line with ECSA's engineering recognition of qualifications in line with those international accords. And when you find a foreign engineer practicing here with qualifications that we have not verified, and with the competency that we have not verified, it's a concern. So indeed, ECSA does not have jurisdiction over any other person, local or foreign, that is not registered with ECSA, but it is encouraged for any person that wants to practice engineering in this country to be registered with ECSA, so that should their work or their conduct be found to be wanting, ECSA could have recourse. You can imagine a person coming here to do work here and leaving the country, and their work is found to be there's not much that ECSA could do, or even when they are here. Yes. To be frank with you, we have not benchmarked our code of conduct against international. It's something that we are working on, but it has not been done. The development of ECSA's code of conduct was primarily informed by the situational analysis here. The engineers here looked at what are the trends, what comes up which require regulation, and that's what informed there. But it being benchmarked against international standards, it's something, I'm talking the code of conduct now. Yeah, the only things in ECSA that are benchmarked against international standards, it's our university programs, in other words, engineering programs, as well as standards for registration. How do you register people? What do you look at when you register a person? But the conduct part, it's a gap that is there that we need to. Yeah, it's something that I'm comfortable to admit. To say it's a gap. Okay. Yes. To my knowledge, no. But I'm saying this under correction. It's something that I can confirm, and once we do the edit part, then we can correct. To my knowledge, if a curriculum of university includes ethics, it will be ethics in the broader sense. But as to whether ECSA's code of conduct has been elevated to be part of the curriculum of university programs, it's something that I need to confirm. To my knowledge, no.
So in other words, ECSA really is the holder of the code of conduct and the custodian of that.
Yes, code of conduct. And the first exposure that a person would have is when they are registered with ECSA, not before.
Okay.
It typically comes, and it's not a secret. I guess perhaps it comes at the wrong time in our country.
Let's just start again.
Yes.
Can you talk to us about fake registration certificates?
Yes. You would recall that earlier on I told you that the Department of Home Affairs has issued a law, a regulation, to say any foreigner that wants to practice engineering in this country need to get a critical skills visa, a visa to do that. Now, the requirement is that before that visa can be issued by the Department of Home Affairs, ECSA needs to endorse or confirm that that applicant has got the relevant qualifications recognized by ECSA. I'm talking academic qualifications, and the relevant post-qualification experience. Because it's one thing to be qualified as an engineer, it's another whether you've got the necessary experience and competence to practice as an engineer. And for ECSA to do that, you have to go through ECSA's registration process, where, as I mentioned earlier on, you'll be the code of conduct and on all those will be covered. Now, a lot of foreign applicants get frustrated with the process and how long it takes for ECSA to okay the application for purpose of critical skills visa. And in 2014, there's been a huge spike of fake letters from ECSA confirming that ECSA is happy with their qualifications and with their experience, as well as fake ECSA registration certificates by foreign nationals. The Department of Home Affairs would, before they confirm and issue a visa, check with ECSA whether indeed the certificate is ECSA's one. So typically what they do is that you will see that the Commissioner of Oath stamp will be fake, or will be yes, or the signature by ECSA CEO or president on the certificate will be fake, or the person who's in inquiries in ECSA would be somebody that doesn't work for ECSA anymore, or doesn't even work for ECSA at all. It's easy to pick up a fake one. Or the registration number itself would be fake, because you take the registration number, you punch it on the ECSA system, and it will be fake. But I think the question that perhaps would be follow up in the mind of anybody is that, okay, what do you do as ECSA when you pick up these fake certificates or bogus certificates? Because if you are not registered with ECSA, there's nothing that ECSA can do. However, we can open a criminal case against you. So all cases of fraud that ECSA picks up by people who purport to be registered with ECSA are reported to the South African Police Services. The one challenge that stands out in ECSA's relationship with stakeholders within the context of regulating the conduct of professional engineers, technicians and technologists is with the Department of Labor. Typically, when there's been a building collapse, ECSA would appoint an investigator, if a registered person was involved, to go and investigate what could have happened. And the investigation invariably would involve accessing the site where there's been a collapse. And the Department of Labor, enjoined by the legislation on health and safety, would generally give us challenges in terms of accessing the site for purpose of the investigation. However, we are overcoming that problem. We are engaged with the Department of Labor. They are beginning to see things from the side of ECSA, and ECSA is beginning also to see things from the side of the Department of Labor. That is the one stakeholder challenge we are currently facing at the moment. Yeah.
Okay. I'm Lerato Primer. I'm an admitted advocate, and I'm the manager legal services at ECSA.
How many cases typically?
Per financial year, we would get approximately 40 cases, 40 new matters. And then we would complete at least 50 matters that we're investigating. So 40 on top of whatever amount we would have had, but our average turnaround is 50%. And I'm not including disciplinary cases. Most of the cases are structural. Most of the complaints we receive from homeowners. So it would be typically a wall collapse or a crack on a wall, or a roof leakage. So those are the type of cases that we get. I think those make up 20% of the cases that we get, because most complaints, like I said, are from homeowners, and it's typically walls or roofs, or a person wants to move into their house but it was not signed off. So those are most of the cases that we deal with. We give effect to our mandate of investigating cases through the investigating committee. It's a committee of 20 members, 19 are registered persons in different disciplines. It could be electrical, mechanical, and then we have one person who's a retired judge. He's a member of the investigating committee. All of the members of the investigating committee, they are called assignees. So as soon as we receive a case, most cases we receive them through a complaint affidavit. We do request that it be in a complaint affidavit format so that it can be commissioned to show how serious the matter is. Because you could have neighbors fighting, and then out of spite, another person could lodge a complaint if that person is a registered person. So usually most complaints are through a complaint affidavit. They come through to our offices first. First of all, we do check if the person that you're complaining against is a registered person, because we don't have a mandate over people who are not registered with ECSA. And then the next step would be to assign it to any member of the investigating committee. They will have a first chance at looking at the case. The investigating committee sits at least 4 times a year. So the assignee would come through to the committee with a report. It could either be a preliminary report, verbal report when they haven't completed the investigation, but upon completion of the investigation, they produce a written report. The committee would then deliberate on the case, and then they'll make an outcome whether there is insufficient evidence of improper conduct, where now administration, being the legal department, must inform the people involved, being the complainant and the registered person, or they can decide that we should investigate the case further, where we would need to appoint an expert. If we need to investigate further, we've got a database of experts throughout the country. That's where now they have to go out and do a thorough or more detailed investigation. Or sometimes the committee might resolve that a written warning, we call it a cautionary letter, or sometimes they can decide that they should sit with a person, where we call it a peer talk, in order to extract more information. The people who would sit in a peer talk would be the assignee, the initial person who investigated the case, and another member of the investigating committee, as well as one legal person from the legal department, either myself or the assistant manager. Okay, after we receive a report, like I alluded to before, that it could either be insufficient evidence or a peer talk or a warning through a cautionary letter, the committee could resolve that we prefer charges. When we prefer charges, it means now we are charging the registered person. We would first send them a provisional findings letter. This would detail the charges. We develop the charge letter through the report that we would have received from the person who was investigating the case. So initially we send it to the respondent, and now the respondent, we give them the opportunity to respond, to differ with the charges, and then based on the response, the case can become a disciplinary case, or it can end there. They might refute all the allegations, and then the case might end there. But all decisions are taken by the investigating committee. Now, if they do not produce anything sufficient, like if the registered person does not give further information that could turn the case in his favor, it becomes a disciplinary case. Now it's all in the hands of the legal department. That's when now we put together charges and we submit a charge sheet. And this whole process, they're given 14 working days to respond to the charges, and then we'll set the matter down for a disciplinary hearing. It's up to them. Most of our cases, they represent themselves. I think the charges are clear. We do a thorough investigation. So most engineers, they do know that we have done a proper investigation. So usually they come forward and try, during the plea bargaining stage, we try and reach a settlement. But at the end of the day, the tribunal makes a final outcome, because in terms of the act, we have to put together a tribunal. It would consist of two registered persons in different engineering disciplines, but one must be accordingly specific to the discipline of the registered person, and then the chairperson would be a legal person. We also have a database of legal professionals. So the tribunal, whether we've reached a settlement, it's still a draft settlement through the plea bargaining stage, the tribunal will still sit, and then the tribunal will deliberate on the case. The case it will be heard as an open disciplinary case, and then will produce the settlement, but the tribunal will make a final finding. They'll either say they'll uphold the settlement, or they can say that they're not upholding the settlement, either the charges that we agreed upon or the sanction that we would have proposed, or both. They might decide that they don't agree with both, and then the case becomes a fully fledged disciplinary case, and it's conducted that way. We only have a mandate over persons, registered persons. We don't investigate companies, unfortunately. Yeah. Since we only register persons, so we can't investigate companies. It depends on a lot of factors, depending on how long the case takes. We rely on the respondent to be cooperative. Sometimes it takes, they might be uncooperative because they might be intimidated by the whole system or the whole investigation. Sometimes we might require more information from the complainant, and it might be difficult to get information from them. And as well as our investigators might find it difficult to get more information and to put forward a complete report. But on average, it could take 6 weeks up to a year to complete an investigation. It's not something we are proud of. We're trying to improve on that, especially because we don't have a mandate to give effect to specific performance, meaning if a complainant wants to have, they're complaining because of a cracked wall, their immediate gratification, they want the wall to be fixed, but we only investigate the professional conduct of the person. So we try and make sure our procedures are quick so that at least they get some comfort in the process. So we're working on trying to improve the turnaround times. Yes, we do, not entirely in terms of our investigation process, but we rely on each other. For instance, the Department of Labor, we rely on them to give us access to the site, especially when there's loss of life. The Department of Labor has the first right to any site. So for our investigators, they need to get on site before it's too damaged or tampered with, or so now we rely on the Department of Labor to give us access. So we're in talks with the Department of Labor currently to try and work together in these investigations. Another stakeholder that we've resurrected a relationship with is the National Home Builders Registration Council, the NHBRC. We used to have a standing committee for investigations because they hire a lot of registered persons, and then they would have a lot of cases where there's cracked walls or whatever the case may be, so they would put those forward through to us. So in the last couple of years, we haven't had a lot of input or feedback from them, but this year we've started resurrecting discussions and trying to make sure we fine-tune our processes, or we help each other out, or we assist each other in our investigations. You know, as far as the engineer, I want to start first from the complainant side. Sometimes you get complainants who are not thorough in what their complaint is about. So that takes the process it drags the process even from the initial stages. So that's also one of the reasons why it prolongs a complaint, because they don't put forward their allegations clearly. In terms of the registered persons, from their side, I think they don't understand the process, so that's why they're being difficult. I think if we give them more information as to what our investigation is about, and that you're not immediately going to be deregistered only because we're investigating you, maybe they might be more cooperative. Because I think they just assume with the police now, we're here to just reprimand, and then that's why they're uncooperative. I think there's lack of information. Yeah, there's lack of information from our side. So we could improve on giving them more information. Typically, we could get an anonymous call, but most often we do keep in touch and check the media reports. A lot of our big cases where there's been loss of life is because of media reports. So through the media, yeah.
Okay.
The disciplinary sanctions are legislated in our Act. So usually the tribunal could either decide that they reprimand the registered person or give him a fine. They cannot fine him more than 20,000 per charge. So it's a maximum of 20,000. It's legislated. Or they can deregister him or her, or they can get suspended. We try and do in terms of trying to rehabilitate engineers while we're in the investigation process, while the case is still within the control of the investigation committee. I did refer to a peer talk. A peer talk is seen as well as a rehabilitation tool, where the assignee and any member of the registered person would talk to the registered person or guide them through what they believe, what they overlooked, or how they can improve themselves as a registered person. But sometimes through that whole process, the report that we might receive from the assignee, from that interaction with the registered person, they might come back to the investigating committee saying that this person was clearly negligent for an average registered person in his maybe status as a professional or a candidate, because we're also responsible for candidates. So it's either they can recommend that they go for a course or whatever, they really just need to fine-tune a couple of things or improve here and there. But sometimes they can either decide that this person knew what they were doing, they were just negligent and they have no regard for the profession and the public, and it might proceed into a disciplinary case. Yes, the complainant can appeal. The Act says any member of the public who's aggrieved by any decision of ECSA, we are the agents of ECSA. And so if any person is aggrieved, be it the complainant or any member of the public, they have a right to appeal against that ruling or that outcome or that decision that ECSA has made. Yes, we can. We've had incidences where we were subpoenaed, but it hardly ever happens, but we can. We currently trying to benchmark our investigation processes internationally and nationally. We've been looking at benchmarking against the health professional councils and the pharmaceutical council. So we are working on, that's what we're trying to do in order to improve our investigation procedures. We regularly look into how we can update or review our code of conduct, and this is all influenced by experience through cases and through interactions with registered persons, or through the number of complaints or the nature of the complaints that we receive. So from there are learnings, and that's when we realize that how can we improve. So we look at how we can review the code of conduct. We want to prioritize the benchmarking of our investigations. When we do our investigations, we do also work with the registration department in that we do check up how have they been keeping up with their standards and their qualification. So that assists in our investigation. And I think the best way that a person can apply their code of conduct, because the first time that a registered person gets to know about their code of conduct is when they are registered. And we publish it on the Government Gazette, it's on the website as well. And when we review it, it's published for comment. We've got all our registered persons on the database, so they are also called upon to comment on the tool that they are measured, that their professional conduct is measured against. So I think the best way to apply it is to continually improve their professional conduct in terms of the CPD, and to pay attention to our website. We do work with volunteer associations as well. Most of our committee members, because ECSA works a lot with volunteers who form part of committees. I think we currently have 45 committees, so most of the volunteers come from the volunteer associations. So we work a lot with volunteer associations when we want to try and get through a message across to registered persons, be it advisory notes on any matter of engineering that we feel the registered persons can benefit from, as well as the code of conduct itself. So we use the registered, we work with the volunteer associations as a communication tool. Our website, we've got a communication department. They go on a lot of roadshows as well as exhibitions. So that's how we try and communicate the code of conduct. But we could improve on it. I think when everyone thinks of ECSA, they just think registration. And then only when there's a collapse, they start thinking, what is ECSA doing? So we could try and get the word out there and try and be relevant as far as investigations are concerned.